Good evening, everyone. We'll just wait for a minute more for the participants to join in, and then we'll start this very, 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 very special. Here we go. The Competition Act was passed in 2002. The act actually came to be effectively implemented only several years thereafter, post which the Competition Commission of India, known as the CCI, came into being, became quite effective in its working, had a full-fledged a team, including 5 members to start with, 5 or 7 members, I think, and a lot of judgments thereafter followed. We've had almost 1,300 cases or 1,300 judgments, almost all of which, or 85% of which have come from the CCI on competition law. It's been 2 decades since the competition law was passed by Parliament. And yet we are calling this a watershed moment. It's taken 2 decades to reach that moment. And it is for the simple reason that this is one of those cases which might completely change the trajectory of how competition law is perceived, is implemented, and the impact that will be felt now by the industry in general, not just the big tech. Go back 10 or 15 years. At that time, this was a watershed moment as far as antitrust laws were concerned in US, in Europe, which were the big cases then. And I was just looking up some of those big cases. I was then a budding financial reporter. And these were the big cases of the last year, starting with of the decade, maybe the 2000 to 2010 decade. Microsoft, you had Kodak, you had AT&T, you had Standard Oil, the big ones. And look at 3-4 years back in the US, you had the big tech, all of them facing the scrutiny of the Justice Department, the Antitrust Commission in the United States, right? From Apple, Amazon, Google, facing scrutiny from the US Senate committee, facing a grilling about their practices, both regulatory as well as competitive. They've all been under fire in the European Union as well. The big tech, but they've also had to face their comeuppance in India. And the man at the center of all the action, the man who led the charge against, if not the big tech, at least one of the big tech, Google, one of the FANG companies, is Additional Solicitor General N. Venkataraman. Over 150-page order, I think it's a 179 or 189-page order from NCLAT, upholding in large parts the CCI order, levying penalty on Google. What's the final penalty imposed by the NCLAT in this case? Roughly amounts to 1337 crores. What's the crux of the case? Of course, sir is going to deal with it today, but the crux of the case is whether pre-installation of the entire GMS suit amounts to imposing of unfair condition on OEMs, which is an abuse of dominant position by the appellant, which is in this case Google, and therefore does it result in abuse of dominance? That's the crux of the case in entirety. When you read that section in competition law, it looks the most innocuous section, so easy to decipher. But when you actually come to implementing it, you have to look at what is the market. You have to see whether the player is dominant in that market. Defining a market itself is not easy. All you have to do is to read Peter Thiel's book 0 to 1, and you realize that all the companies will define the market, how they perceive it. And then, of course, the Additional Solicitor General Venkat sir had the tough task of establishing that Google was dominant in the market and then abused that dominance to its advantage. That's exactly what the NCLAT has held. It may be on some of the points they may have toned down the rigor of the CCI order, but in large parts they have upheld the CCI order. They've gone on to say, in fact, that Google leveraged its dominant position in Play Store to protect its dominant position in online general search, which we all use every day, and also abused its dominant position by tying up of Google Chrome app with the Play Store YouTube app with the Play Store in breach of the Competition Act's key provision, Section 42E. And therefore, in light of these findings, they dismissed Google's appeal. They directed Google to deposit the amount of penalty within a period of 30 days. It is a watershed moment. This will have an impact. Venkat sir, Additional Solicitor General of India, we all know him for all the landmark tax cases that he's argued. Every time we've introduced him at our conferences, events, even on webinars, we kept on saying that he's played such a key role in evolution of tax jurisprudence, one of the youngest senior advocates to be designated in this country. And at that time, he was in the Madras bar. But from then to now, sir, we can no longer call him just a tax lawyer. Sir is arguing big corporate and commercial law cases, none bigger than this in the last few years that has come in the competition space, argued by the man you can see on the screen, Additional Solicitor General N. Venkataraman. He will, over the next 60 minutes, deal with what this case is all about, what are the key issues involved in the Google antitrust case, or in this case, the anti-abuse of dominance case, the key issues involved here, CCI's findings, how the NCLAT has upheld in large parts the CCI order, what this means for the industry as well as big tech in India, and why this is a fillip to the Make in India movement, as Venkat sir likes to call it. It is a big moment, and we are going to be hearing from Venkat sir in just 30 seconds. Till that time, please allow me to plug in Law Street India for all of you. This is Tax Sutra's corporate and commercial laws portal. In case you're not a subscriber to this, you must, because this is one of those very rare portals which covers company law, SEBI, SAT, FEMA, RBI, IP law, intellectual property laws, as well as competition laws. We have the only competition law database in the market. You can search cases by industry, by issues, and those issues have been filtered right to the minutest of issues. Google will, of course, find prominent mention. At the end of the webinar, I'll get my colleague Manjari to showcase the competition law database. For now, I hand it over to Venkat sir. Venkat sir, first of all, congratulations for the big win. I know there is a Supreme Court hearing that will await you in this case. Till then, of course, this ruling holds. A big one of that we all want to hear from you, sir, the man in the hot seat. Thanks, sir, for joining in. Really a delight to host you. Ever grateful.
May I start, Arun? Namaste, Sharade Devi, Kashmira Puravasini, Twamaham Praptaye Nityam, Vidyadanam Chidehini. Dearest Arun, and all the friends in Tax Sutra, and all my professional colleagues with whom, most of whom I would have interacted, appeared for you and worked with you long hours. It's always a pleasure to connect through Tax Sutra on an important landmark judgment and deliver a speech. Arun has always been very accommodative and kind in hosting me in his platform on milestone judgments. So when this judgment came, when he requested, I said, I'll first opt for you. And therefore, it's a promise to Arun, and very, very happy to speak through Tax Sutra and the Law Street Journal on this important case. Having completed 34 months of work as a law officer, if I can mark 5 most important decisions or cases which I had argued in this 34 months, Google will be one amongst the 5 top. Antrix Devas was one important case. Then the case on charitable institutions was again very important. Google is again the 3rd important case. And we have argued.
So Mohit Minerals as well as the reassessment.
Yeah. VKC, Mohit Minerals. And then, of course, we have argued the MFN batch and its orders are reserved, awaited. And also before the Karnataka High Court on the online gaming, GST on online gaming. So these will be 6-7 important matters in which On competition law, Google is a very, very important case for all of us as professionals to understand what this law tries to our endeavors to deal with. That's more important than a judgment of the case alone. Before I set out as to what this case is all about, some interesting 2-3 aspects needs to be also placed on record. See, this is one case very, very challenging as a professional, very challenging. It was a most well-fought adversarial litigation in my life. The competing counsels on the other side representing Google had put a very strong and enable fight for weeks before the NCLAT. So they actually escalated the intensity of the debate on this issue. And therefore, we had to work a lot and then do our matters. So this success cannot be enjoyed by me alone. It will be extremely wrong to perceive it that way. It's a complete team effort. Thanks to the entire team in the Competition Commission of India, over 10, 12 people. They all work for about 25 days, 3 hours a day. So thanks to CCI for their such a coordinated, able technical support. The kind of knowledge they could impart to us on this new law, emerging law, especially from the economics point of view, from the business point of view, from a competition point of view. So we owe a lot to Competition Commission of India. I also thank my 2 briefing counsels, Samar Bansal and Manu Chaturvedi, who slogged it out day in and day out. And, thanks to them. Likewise, in fact, the senior counsels who appeared for Google were also so kind enough to acknowledge in the court the support given by their technical teams, by their lawyer teams, by their firms. Immense support were drawn. There are so many youngsters. What was so nice to watch in the proceeding is the whole NCLAT main hall, the main court, first court, would be completely full, and 95% of them being youngsters, upcoming young lawyers, watched these proceedings. And most of them supported and worked with the Google team. So it was such a refreshing experience. But to top it all, see, we might have argued it for almost 3 weeks, daily from 2 to 4. But it is amazing that both the honorable judges, Honorable Justice Ashok Bhushan, the honorable member Dr. Alok Srivastava, could compose and deliver a judgment in just 6 to 7 days' time. A very detailed judgment of 189 pages. Had they got more time, maybe they would have added more also. Because of the time limit set out by the Supreme Court as 31st March, 189 pages, well authored, well considered, assimilating all that we have fought by both sides. So it was a complete effort by everyone. If there is a good judgment today, it's only because of the effort of each and everyone collectively. So all of us together have got out a good judgment for us to now discuss. So this is, I thought it's a very important piece we should share. And may everybody be complimented for their wonderful effort in bringing out this case. The third aspect, before we go into the merits, there are 4 or 5 important points that we need to certainly bear in mind, because the sanitization part of the judgment is very crucial. The NCLAT was kind enough to record the following as findings. Number 1, the investigation by the DG in the CCI has been very fair and reasonable. That's extremely data-driven. This is one finding given by the CCI. 2, that the CCI as an adjudicator has been very fair and reasonable and has not violated principles of natural justice in rendering its detailed order running to almost 400 pages, impregnated with contentions, reasonings, findings, and data. Second important point. Third, it has upheld repeatedly in various parts of this judgment that CCI and the DG had driven this whole case based on data and evidence. So whatever has been reasoned out is sustained based on data, based on evidence. That's the third important finding. And fourth, the submission that we have, because European Union passed the order against Google in 2018, that has been followed ceremonially by the CCI was also rejected, saying that there is no bias. It is an independent, concrete finding after reasoning out the contentions raised by Google before the CCI. Therefore, there is no comparison bias. There is no bias that way in following the order of the European Union. Indian CCI order will stand on its own strength. These are very, and five, that the way the investigation happened, that was also challenged. See, it was a very well fought case, I should say that. So that was also rejected, saying that the manner in which the investigation, the probe has gone into, in picking up the details, in asking the questions, in collecting the data, has been very fair and reasonable, and no prejudice has been caused to Google in the process. So these are five important findings besides merits: upholding the work done by DG and upholding the work as an adjudicator done by the CCI. And you must understand, CCI has a composition of legal experts who works. There are very many lawyers who are working for CCI full-time as employees. And you have a huge economist drafted from teaching, from industry, from experience. So you have different types of people and people who understand commercial business models very well. So it's a composition with all this who work a particular adjudication. This is the background in which an order gets passed. Okay, so now let's come to the merits. What did the court decide? See, a brief idea on competition needs to be first narrated to all of you, because it's a growing law. See, competition law all over the world is something to do with market correction and market regulation. That's the essence of competition law. Any business conducted in any part of the world must not be anti-competitive. It should be fair and reasonable. If it is anti-competitive, then the market regulator, which is the antitrust commissions in various jurisdictions, which is the Competition Commission of India in our case, has the right to probe, investigate, and regulate it through an adjudication process. In fact, a question did arise. Did Competition Commission explore in a very fair and in a very detailed manner, which I had said that it had already sustained its case on that position? Okay, so this is the broad role of a CCI: to prevent, to protect, and also to adjudicate and regulate the market. Essentially, the dispute can arise in three areas. Essentially, then it can be in other areas also, but essentially, Section 3 deals with anti-competitive agreements. For example, something which all of us are very familiar is formation of cartels. Cartelization is considered to be anti-competitive. Section 4 deals with abuse of dominance. Somebody who is a dominant player, there is a restriction, there is a limitation that such a player should not abuse his or her dominance. Now, the third is Section 5 and 6, which deals with combination of or merger amalgamations. All those combinations should not result in a monopoly or an anti-competitive exercise. So these are the three huge verticals in which this law gets examined. Now, when you examine, there are two important tests which are applied individually and independently depending upon the underlying case that is being examined. One test is called the appreciable adverse effects on competition, AEEC, appreciable adverse effects on competition. And the second test is the abuse of dominance. Now, this AEEC is a doctrine or a test which will apply to anti-competitive agreements under Section 3. And again, in proving the case when it comes to the resultant combination out of 5 and 6, merger or amalgamation or acquisition or share patent, all this can have an impact of an appreciable adverse effect on competition. This AEE test applies to 3 and 6, essentially. The other test, what is called as the abuse of dominance test, applies to Section 4. So even though it was contested by them that even for Section 4 of abuse of dominance, you should prove AEEC test, that contention stood rejected by the NCLAT. Because they said, you see, what we argued was if you impose AEEC test on abuse, then you will, the vice versa will work. You will start saying you should prove abuse of dominance in Section 3 and Section 5. So we are changing, instead of one test, we are putting plurality of tests and we are swapping the test. So NCLAT rejected the contention and said, for Section 4, it is more than sufficient if abuse of dominance stands for. That's the principle in which we have constructed this case. All right. Now, what do you mean by abuse of dominance? There are a few steps prior to reaching that destination of abuse. What are those steps? The law is quite clear. It says everybody has a right to promote their market. So you should not think competition law has a hold on you. See, income tax law doesn't put a cap on how much of income one can earn. It only says, regulates, if you earn, please pay your taxes properly. So competition law can never strangulate a business house. And that is not how the law is conceived, and that is not how the law gets implemented also. So it allows anybody to grow to any extent. But there are some riders. By virtue of your growth, if you become a dominant player, then the law all over the world obligates you to carry out certain special responsibilities. See, if you want a comparison, see, all of us are citizens of this nation, but it is few who get elected as MPs and MLAs. It is the fewest who become ministers. It is the fewest who become judges. So when you hold a constitutional position or you hold an executive position, which is by virtue of a constitutional mandate, for example, an election commission. So these are all constitutional positions. When you may see, you continue to be a citizen, but when you hold that responsibility, the Constitution demands you that you have an obligations which are far, far greater than that of a citizen. These are added special responsibilities which the Constitution, based on constitutional trust, based on constitutional morality, demand from you. Likewise, in market regulation, there is a need, there is a compulsion that anyone who becomes a dominant player carries with him or her the role as special responsibilities. This is the terminology used all over the world. What do you mean by special responsibilities? The moment you become dominant, there is an obligation on your part not to abuse your dominance. It is a mandatory requirement of the law. The law enforces it on the reverse obligation principle. you are supposed to regulate yourself because you are dominant. Why? Because once you reach dominance, there will be an inherent tendency to abuse. And therefore, this regulation is imposed on that person, on that entity. So, one is reaching the position of dominant. Two, once you reach, there is an obligation cast on you all over the world to act in a very responsible way. And three, when there is a breach or an infraction or a dereliction or a non-compliance of this responsibility, then the law showcases that breach as an abuse of dominance. This is how the law has grown. So, for example, if you deny access of market, if you limit, restrict innovations, if you impose terms and conditions which are unfair, then you move away from your special responsibilities and commit a breach resulting in abuse of dominance, is what the law conceives it. Now, both economics and the competition law also recognizes one more important principle. It identifies dominant players into two buckets: dominant and super dominant. So when somebody holds a market share above 80%, above 90%, then such a person is identified as a super dominant player in that market. That's how the law recognizes it. There's no definition of super dominant in the law. This is all grown over a period. See, this is a law completely mixed with business economics, market economics, and say public finance. All these connected branches hold this law. The underlying positioning of these parameters are recognized in this law. So if somebody reaches 80 to 90%, then that entity becomes a super dominant player. And Google, all over the world, is recognized as a super dominant player, as it holds 80%, 90% of the share in various parts of this globe, more so in India, where it almost has 98%. That's how it has been conceived. So if you hold 98%, and if you hold the status as a super dominant, and if you breach your responsibilities, then the market regulator, competition commission, has a right to course correct it by holding such a conduct as abuse of dominance and suggest and direct remedial measures as one part of the obligation, and also impose penalties for such an infraction. This is exactly what CCA has done in this case. Its final findings, after all the findings, it has issued a set of directions, about 10 directions, that Google henceforth should do the following. And for having committed a breach and having abused the dominant position or the super dominant position, Google has to pay a penalty of what Arun was saying, 1337 crores. So these are the final takeaways or outcome from the CCA order, which has been upheld by the NCLAT, of course, on 4 remedial actions, which I will be dealing a little later, which covers less than 3 to 5% of the whole order of the CCI. 95 to 98% of the order remains confirmed. Hardly 2 to 3% of the order alone focuses on these 4 remedial measures, which I'll deal with a little later. Otherwise, the order has been upheld in total. Now, so this is the broad conspectus of the law and how the market regulator has approached this law. Now we go to the next phase. How did it approach it factually? That's what all of you might be interested to know. See, it's a very simple phenomenon. It's the business dynamics are quite very unique. See, here is a case. Ultimately, it is the consumer holding a mobile who is now being what we call it in economics, a status quo bias gets created in him by making him use a particular operating system and a set of defined core application bundled apps. Simple. So the question you should ask is, when you are not even a manufacturer of phone, and it is not that you produce the phone, load your own apps, load your own operating system, then release it. It's not a business model of that. Number one. Number two, all right, if that is not the business model, if the entity is holding its operating system as an IPR, and it has purchased all these apps and holding this also as its proprietary, has it licensed these OS? Has it licensed these apps as a licensing model and earned revenues and royalties? No, that's not the business model. So it's not a wholesome model as a producer, nor is a model of licensing. This is the dispensation which it has been doing for the last 15 years. See, it acquired the Android OS. It became the owner of Android OS, which is an operating system on a phone. Then it initially allowed everybody to use it, prepare forks, prepare apps, all that, to ensure people get used to it. Once it found a legitimate use up to a point of time, then it started to migrate into a closed circuit licensed environment. It moved, because you may still find some open licenses available, but no way a match to what happens to the business reality. So the players are the following. You have different branded phone manufacturers who manufacture only phone. You have huge number of players who produce various applications. And of course, you have a huge consumer base. In India, it is about 98 to 98.5% of the whole phone base. So how do you interconnect? You ensure that the producers of phones fall in line with your operating system. You ensure the app producers produce app captively for you. And more importantly, you ensure that the customer base is retained by you, neither by the app producer nor by the manufacturers of phones. Because it's one who produces phone doesn't produce a OS. One who produces an app doesn't produce a phone. So these producers are different, and you hold the OS and the power to integrate the apps through the OS into the phone. This was the power you could be, in essence. And therefore, it chose to enter into 3 different agreements. Agreement 1, Agreement 2, Agreement 3. And all the 3 will have to be bundled. It was argued it is voluntary, it was argued it is optional, all that was argued on a very, very high legal plan. Judgments were cited by both sides, and how we also argued, and we placed Supreme Court judgments to say, you can have one agreement having everything in one document. You can have the same theme split into several agreements, as long as the contracting parties are one. as long as the contracting team is interconnected, then our Supreme Court consistently has held that plurality of agreements cannot result in dissection or reading them as separate. You have to read them together as one whole lot. That's the law of our nation. And therefore, applying that rule, NCLAT upheld that though these agreements are three, they need to be read as one unison whole between Google and its OEMs. So, when you do these agreements at large and say it mandates the OEM to give an undertaking that it will not prepare forks. So, you will only prepare a phone which can only accommodate an OS without any forks of your choice. It shall be the OS as mandated by Google. Is one type of a condition. Similarly, when you have the apps, you demand a pre-installation. You demand a particular placement. You demand that when clicked, this should follow the sequence. You demand every phone you produced needs to be verified by us and checked by us on its alignment. And you also say, I will give you a bundle of 11 apps. It's up to you to take all of them, take all or leave all, which they themselves called it as the core application apps. So take it or leave it. And for all that, if you take it, and if you agree not to produce forks, you will also get a revenue share for agreeing to be in alignment with this philosophy. The fraud continues. Let's not go into too much of technical details for a common man to understand or a professional to understand. It should be enough. Because all this is found in the order, which is in public domain. So, a collective interpretation of all these clauses ensure. See, the CCA has confirmed, if you read section 4, which talks about abuse of dominance, there are 5 subcategories of dominance, abuse. And CCA had sustained all the 5 categories. And it's good fortune of the CCI that the NCLAT has also upheld all the 5 subsections as abuse of dominance, without any exception. For example, if you enter into such agreements, CCA has found that to be, which was upheld by NCLAT, found that to be, you are using your super dominant power and entering into unfair terms and conditions, therefore violating section 4.2 subclass A. By disallowing people to be innovative, because you don't allow them to produce forks, the court upheld that this limits or restricts scientific and technological innovation, and therefore there is an infraction of section 4.2b. By having a very closed door environment, in fact, the CCA has given a very positive, the NCLAT has given a very positive finding. It says it is very surprising in 15 years, we don't see new entrants at all. And over a period of time, we only see branded entities getting exited from the scene. So it concludes there has been a denial of market access, resulting in an infraction under section 4.2c. Then, if you read all these 3 agreements together, if you sign A, you will have to follow supplemental conditions B, C, D, E. By complying B, C, D, E, you will get a revenue share of E, D, F. So you try to combine your network and leverage it and ensure supplementary conditions also get performed by you. using your power of dominance. The court found this is an infraction under section 4.2d. And more importantly, the three crucial tying arrangements: Play Store with Google Search, Play Store with Google Chrome, and Play Store with YouTube. This tying arrangement has ensured preventing anybody else to enter market and ensuring you enter more and more the market and penetrate it. And you also protect your existing market and keep expanding. And therefore, you have violated section 4.2e. Therefore, all the 5 infractions, that's why we keep saying this is a textbook case authored by the NCLAT on abuse of dominance, because you find all the 5 infractions happening and being discussed and very, very well fought. Each one was fought separately on a day. Each infraction, they took it for a day and argued it. And we took half of their time to say how they are wrong. So it was a well-fought battle, well considered order also. So this is how that all the 5 infractions was found to be, there is an abuse of dominance in all these areas. If you translate it into a commercial reality, how did it happen? See, this structure is like this. If you see the pyramid, in fact, there is an economic principle, what they call it, castle and the moat theory. This castle and moat theory fits into this case. And how? See, who is at the tail end? The tail end has the ultimate consumers who use the phone like you and me. Now let's gravitate from there. You are one amongst the 98% users of the OS and the 11 apps. So how have they structured it through their agreements? They have structured it in 3 types. The top of the pyramid will be the Google search. The next immediate step would be the browser. And the next immediate step beneath it will be the various web search points. And beneath it is where you as a consumer will allow the data and traffic to pass through these 11 apps. So your data, your traffic is ensured to pass through these 3 gates: the gates of web search points, the gates of a browser, and finally through the search. And it was proved as a matter of fact. That's why tying became very important. 99% of the data and traffic ultimately went through the search, the Google search. 99% of the data. And the rest of the 7 search engines all over the world could generate just, we're talking about Indian statistics, could generate just 1% vis-a-vis the 99% of what Google search could do. So beneath it, you may have browser A, browser B, browser C, browser D. Suppose they are all connected to Google search. How does it matter? You will have several web search points. If they are finally connected to these browsers who are connected finally to Google search, how does it matter? Statistically, we showed that Google search has about 99% holding of data. Google Chrome, 70–80% of it. And the YouTube, it is 99.5 statistically. So this was the kind of usage. You could the data and traffic that could pass through these filters. And what is the outcome of it? Outcome of it is our data and our traffic, when it passes through all this, get ultimately monetized as advertisement revenues for the entity. And the numbers are quite mind-boggling. It's all there in public domain. We also placed it before the court as a matter of statistics. It was also not disputed, quite a large number. So ultimately, it became, this is how it became a revenue generating machinery. So if you apply the economic principle of castle and moat, if you consider Google search as the castle, then you construct the Chrome, you construct the web search point, you construct the rest of the 11 apps, and all that is created as a moat to ensure the castle is preserved. What you also call it in economic terms as the walled garden approach. Walled garden approach. So this was considered to be an abuse of dominance. Why? So this is the broad commercial understanding how our data and traffic using our mobile phone, using these apps, finally through Google search, allows Google to monetize as advertisement revenues, which it shares with the manufacturers of phone, which it takes a commission from the app producer for uploading their apps. And it was also sharing, you won't believe, you may not be allowed in the open license for your systems to be integrated, but you may even go to a competitor and say, let anything be your browser, let anything be your apps, let it converge with Google search, for which I will be ready to compensate you. So it was that extensive a reach, which in terms of section 4, 2A to 2E, was found to be abuse of dominance. Now, this is broad understanding of commerce. Now, because being professionals, and some of you might even be students of economics, the following principles of economics apply. See, this is a law driven completely by economic principles and theories. So in the process of our arguments, we grounded all these by putting it on the larger canvas of market economic terms as choke point. Many authors call this as choke point capitalism. Some call this as digital hegemony. These are all economic terms. Dynamic leveraging, cross-subsidization, status quo bias, network effects, high entry barriers, interoperability issues, gatekeeper position, default choice, foreclosures, dotted line contracts, entry deterrent strategies, take it or leave it all, and wall garden approach. See, in contract writing, in fact, the NCLAT has also followed the Supreme Court judgment. See, we have evolved a theory over a period of time that a one-sided contract, a dotted contract, a contract where you have a dominance over the other, is considered to be a contract where there is uncontrolled bargaining power of the dominant entity. And that is considered to be an abuse of dominance under 4.2a for imposing unfair terms and conditions or discriminatory terms and conditions. So these are all the various technical or economic terms used in the whole approach of this case for ultimately doing it. Now, this is how the order got confirmed. Now coming, I should be fair in also disclosing what was allowed in their favor. Only then this will be complete. See, 6 out of the 10 were held in our favor, and 4 out of the 10 were held in their favor. But these are marginal reliefs. For example, the NCLAT said you don't have to force uninstallation as a condition, which was one of the remedial actions which we had recommended. But when pre-installation is found to be abuse of dominance, then uninstallation will play no significant role. So 1 goes. 2, on side loading, we ourselves volunteered in the court. A reasonable warning is enough. The court has said reasonable warning should be sufficient. So there is something, there is a consensus. We have also to that extent agreed before the court. Excessive, instead of excessive warning, a reasonable warning is sufficient. So that's a second relief. They could eventually get it. Now, the third one was on the API. See, this is a very important point. When you have the API as nothing but the proprietary rights in developing apps, because they are proprietary rights, the NCLAT held that this cannot be given free. This is one's invention, one's ownership. It's an intangible property. So you cannot demand it for free. So they are entitled to incentivize it. They are entitled to monetize it. But remember, so this is one relief they got, but this is subject to, again, competition law. When somebody comes to enter into an agreement, that agreement has to be fair and reasonable. That agreement should not become anti-competitive. That should not result, again, because they have followed, this should not result in an unfair terms and conditions. But as an owner, you are entitled to monetize it. And the last one is using the app stores through the Play Stores, which NCLAT had held that even CCI had not given a separate independent finding of any abuse of dominance on this. And therefore, to that extent, the remedial action needs a course correction. So these are the 4 marginal reliefs which was given to Google. Otherwise, infraction between 4.2a to 4.2e is intact, complete, and that has been upheld. Now coming to the penalty part. See, this budget, this few days back, we have moved few major amendments to the Competition Act, and 2 of the major amendments needs to be referred as part of this discussion, because most of you are professionals. One of the amendment now recommends a settlement process, which is a big, significant welcome step. So instead of going through a huge, humongous investigation process, followed by an adjudicatory process, followed by an appellate process, and finality getting reached. So if the entity feels that it can participate and settle the dispute immediately, it is extremely advantageous, because the market correction will happen in a very rapid and quick way. So this is one amendment which has been brought out now. Now the second amendment is in terms with the global practice. See, so far we had penalty provisions in the Act taking the India turnover for the last 3 years and then imposing that 3 times. Or there is a mechanism, but I think it's 3 times. You can go up to 3 times the penalty. See what happens with MNCs, which has a global reach. This was one typical case where, in spite of which has all been properly recorded, fortunately also by the NCLAT, that there has been a serious exchange of correspondence, and we found that Google was not very cooperative in divulging the turnover details. So we had to calibrate it with the available data, and we have imposed a provisional penalty, reserving the right, which again has been reversed by the NCLAT to say that you have imposed a penalty and that should be held as final. So now we have amended the law in line with the global practice, that if an entity has a global presence and a global turnover, and if its practices are found to be anti-competitive in nature, then we are entitled to impose penalty equivalent to their global turnover. So that all this confusion of producing evidence, chartered accountant certificate, all this can be dispensed. And your global balance sheet will certainly reflect your global turnover. There's no difficulty at all. It's a document which will be available in public and for access. So this has also been amended because of this part of these experiences in finding it difficult to assess the actual intrinsic quantum of penalty. So this is how this law finally has taken shape. Then there are 2 findings which has been imposed against a CCI. One is on penalty, confirming it no longer as provisional, but final. And the second one, where we are ourselves working into it as to find out, it says it has been our case that when it comes to abuse of dominance, there is no question of exactly proving the effect to the percentage level. In this case, it was a super dominant player, and the extent of abuse was discernible through perfect data. 98%, 98%, 96%. All these data could be gathered because it was super dominant. But it may not be possible in every case. So we had argued that once you derelict your special responsibility, enter into an unfair agreement, deny market access, prevent innovation, then you are considered to be an abuse of dominance. The NCLAT has said that FX tests should be proved. Even though we have consciously, the legislature, it was discussed in the standing committee, and it was finally felt that effects should not be part of law. There was a clear dispensation of the condition. And therefore, this is one area where CCA will be exploring the legal options as to what needs to be done in due course. So these are two findings which the NCLAT has rendered against the CCI. Rest of it otherwise has been upheld in total. So this is, Arun told me I will be 45 minutes, so for 45, 50 minutes. This is the broad, big picture of the Google case. And if there are any questions, I'll be very, very happy to take some of them with the time available. I don't have constraint in time, but I don't know about Arun and all of you. But it's really, really a pleasure for providing Arun for providing me the opportunity, and over 200 participants willing to join and spare your wonderful, valuable time with me.
So our pleasure. We have so many, we have a lot of jurists who joined the webinar today. A pleasure to be hosting.
Thanking all of them, all the seniors, everybody personally.
Yeah, a lot of policy makers who are here today. So policy implementers are here. Wonderful to host them. So we have a couple of questions. I'll straight get to them. First is from Mr. Venkataraman. What would from Mr. Venkataraman to Mr. Venkataraman?
Oh, okay.
What would this mean to Google and to other app developers going forward? Should Google change their way of doing business going forward? I'm assuming yes, but sir, we want to hear from you.
No, I thought I will wait for the question so that I can answer this. See, I've made this statement even in the PTI interview, and I repeat it. See, this judgment will have a direct bearing on the policy of the government on Make in India vision and also startup growth. I wanted to spend 5 minutes on that.
Sure.
The time. How do I say this? Is there are we making a statement just to please the government? No. Why? Because see, India as a country today stands with pride to claim the two largest electronic gateways are done only in India and by us. One is the UPI gateway, the other is the GST network. All of you can go and log in. We just logged in an hour back before the stock. I wanted the latest details. December 2022. You know the number of transactions that had happened in 1 month through our UPI? 782 entries, crores. 782 crore entries in our UPI gateway. 1 month. And the quantum or the volume of transaction is 12.8 lakh crores. Accounted transaction. If you come to the GST network, before GST in 2017, we had hardly 60 lakh assessees registered. Today, it is anywhere between 1.2 crores to 1.4 crores. And systematically, the failure rate is negligible. Is there a failure rate at all? No. It's going so smooth. We have hit the latest month target. We have crossed 1.6 lakh crore tax collection. Highest. So, when we are blessed with such capacities, and when 98.5% of the consumers in India are now using one particular OS and 11 apps, is it not the time for us to think our capabilities to produce our own OS, when we can produce such a big UPI system, such a big GST network, our own apps? So you ask yourself, based on this data, 782 crore entry can happen in one gateway without a failure rate. If this is the capability we have, should we not think ahead and make the dream of Make in India and startup to become a reality? I leave it there.
Yes, one would only, if I were to hazard or dare to have a contrarian take, it would be that India has not been the hotbed of innovation so far, sir. If one thing, and in fact, you've had now people saying that the big five in India should be broken up because that is fueling inflation. And these sort of policy debates are good to have. But the one thing India has distinctly lacked, sir, has been the lack of innovation, including in the information technology space, where and maybe we need to do something to fuel more innovation.
Good you told this. I would only request all the professionals to log into the MIT site, MEIT, Ministry of Information and Technology. They have published 2 bulletins of a vision map till 2026, 2027.
Yeah.
What is likely to be the explosion and growth of India on innovation?
Yeah.
We are looking at a reach of about 300 billion USD, of which 60 billion USD relates to the phone market.
Yeah. So, just to give a context, and I'll get to the next question, but just to give everyone a context, I opened one of the panel moderations by asking a question to the audience. This was in Delhi just after the budget. Can anyone hazard a guess as to what is Google's cash, cash lying in the bank, the surplus? And I did not get a single correct answer. It's roughly $150 billion. That's equivalent to India's profit. That is corporate India's profits in totality is roughly 12 lakh crore, which is equivalent to Google's profit. So 1,300 crores, so, quite honestly, should be coughed up without.
No, we have given some numbers to the court, which I don't want to be saying this in public domain, which is slightly higher than what you're saying.
Oh, great. Absolutely. So the next question actually is quite interesting, maybe connected to what we've just spoken. And this comes from Mr. Chinmoy Roy. Yeah, Mr. Chinmoy Roy asked this question. At the outset, thank you for explaining this complex modern issue in such a simple, enriching manner. I wanted to know if the penalty on the global turnover is also followed by other jurisdictions, or is India leading the way with this novel approach?
No, it's not novel. European Union already has. See, the very same entity in 2018 was found to be abusing its dominant in European Union, and a penalty has been imposed on the global turnover, and that penalty has been fully paid, complied.
Okay, wonderful. So yeah,
that's the straight answer.
Yeah. Mr. Kamal Garg asked this question. How do you see the effect of this judgment on Google's position in other countries?
See, it's like this. We understand in some countries, they are having a very restricted practice. They are following the law of competition in some countries. Their own agreements carve out those countries. In countries, some few other countries are already investigating it. So European Union has finalized it. We have also finalized it. Yeah. In fact, US Antitrust Commission has also been recording a lot of evidence, much of which has been referred and relayed also by the DG, which we also presented it to the court. Because one of the contention which came up for consideration is this. See, this is a very important point. I think I failed to say that. It's a very important point. They argued. Every argument was they were trying their best. We should say potentially worked very well. See, they argued. Look here. What is CCI doing? My OEMs are keeping quiet. My app developers are silent. My consumer base, 98 or 99, they are silent. Nobody is retaliating. Why the hell are you calling us an abuse of dominance? That's the point. So we have to handle it in law. So we placed authorities to say, look here, we as a market regulator have a responsibility, as a statutory responsibility. We don't have to wait for your OEMs or somebody to come and cry that there is an anti-competitive practices. And therefore, at that point of time, one of the contentions raised was, look at the set of evidence recorded by the OEM vis-a-vis these market players who are all failed in the market. Whom should we trust? So NCLAT resolved it, saying that all these people are agreement holders with you. All these people are beneficiaries of your revenue share. So between their statements and the statements given by these entities, which is all recorded by various commissions across the world, we would let credence to the statements given by these entities. That was the finding given by NCLAT.
Yeah. Sir, two more questions I'll take, and we are happy to take more. So keep them coming. Mr. Anand Narayan asks, sir, thanks for explaining the NCLAT audit in a lucid manner. It would be great if you can share your valuable views as regards the proposed law to regulate tech firms from a competition law point of view, whether there is a need for an ex-ante regulatory mechanism in digital markets.
See, I'll answer it this way. See, finding the need, I think we are also working on a supplementary law, identifying specifically for digital competition. So in all likelihood, there will be one more legislation, a supplementary legislation to the parent legislation, focusing on digital competition. Because that is something that is happening in European Union. It's going to take effect from January 2024. And other parts are also examining it. See, digital world, it's a real Maya. I have to only speak it from a philosophical perspective, because it's like Atma. You'll never know where it lies, its presence. So it is a very cross-border digital law. It's the most complex, rather impossible law to manage today in the world. So taking that cue, we are regulating it. And we are focusing in bringing out an important law, supplementing the main law, and hope if that falls into place, your question would also get answered in the process.
Yeah, so I'll ask before I go to the next question. So just one observation, more like someone who's observed the CCI for the last decade or so. Generally, sir, I have also appeared before the commission to argue a case which I had petitioned against a statutory regulator, and the prima facie opinion was in my favor. But sir, to be very fair to them, they seem generally consumer friendly. When not that they're anti-corporate, anti-industry, but they've generally tried to be consumer friendly in their approach over the last decade.
I'll give you a parallel example. I'll give you a good example so that you will understand. Sure. We are now fighting a batch of cases in anti-dumping in different high courts and also in the Supreme Court, where, see, 99%, whenever the designated authority recommends, we translate it into a notification and impose anti-dumping duty. In very, very rare cases, the recommendations are not taken into consideration and we don't issue notification. Now that is being challenged, saying that when it has been recommended, why have we not translated? For every case where we have chosen not to translate into a notification, we give adequate reasons, bearing in mind the consumer interest. Bearing in mind the consumer interest, which will not see, these are all government file documents, which will not be, we can't be making everything public because it's a legislative mechanism. So the world will think, look here, they are picking and choosing. 99% we translate, 1% we don't translate, for which we have records. And in that record, we find what is good for ultimately the consumer. By imposing anti-dumping duty, the consumer should not suffer.
Yeah.
Now, will you call this exercise pro-consumer or neutral? It's a debatable question. It's a perception.
Yeah.
Likewise, when a market regulator understands consumer perception, see, for example, this I'm saying in my private capacity, not as a law officer, not as a counsel for CCI. Look at this, your data and my data, they don't pay us, and that is getting monetized. So what are we supposed to do? Is it consumer friendly or consumer unfriendly? It is something which we need to debate.
Yeah, and we have no choice but to accept those terms and conditions.
Yeah, dotted lines.
Yeah.
And so these are all perceptions, perspectives.
Yeah, anti-dumping is a little more tricky because both the sides are Indians, of consumer as well as the industry.
And
So,
therefore, in some cases, when we don't impose, the decision is taken for the consumer. He may have to import it at
got
this
it.
price so that
Yes,
he doesn't suffer.
absolutely. Absolutely.
So you keep questioning all this.
Yeah. These are all policy and legislative. These are all policy considerations
Correct.
in a given set of circumstances and at that point of time.
Correct. Correct.
Absolutely. So the next question is from Sarneet Kaur, and she asks, sir, provided that the CCI has won the matter, would it be appealed to the Supreme Court for the 4 marginal remedies set aside?
You should ask CCI. See,
okay.
these are all matters of strategy which we can't definitely reveal at this point of time.
Yeah, that depends on whether Google is going to go to Supreme Court. Let's wait for that.
Partially true.
So the next one is from Mr. Akela Prakash Rao from Bangalore. He says, can this decision be extended to cover the practices of corporate hospitals nexus with their in-house diagnostic centers and dispensaries?
We need to see.
So, but how many of them corporate hospitals may cross the threshold under the competition law? Yes, sir, please.
So, see, though oranges and lemons belong to the same family, though tigers and cats belong to the cat family, we need to know whether something is a cat or a tiger.
Yeah.
So I can't give you a ballpark answer, it will be very vague. But this judgment defines what is abuse.
Yeah.
Qua every subsection.
Yeah. And what is an anti-competitive practice? So I think the 4 words that you underlined, sir, in the beginning.
No, AEC will apply for 3 and 5. Here it is only abuse. Now, abuse has 5 divisions, five variants. And how these 5 variants play has been found. It's a textbook case. It's a textbook authority.
Yeah. So the last question comes from Neetu Gupta. She asks, by any means does this place India in an disadvantageous position because there are thousands of app developers, digital marketing professionals who are working in India for Google and paving way for digital advancement of the nation?
See, the nation has now chosen a philosophy, and it is up to us to align ourselves with that philosophy. I'll just give you one data which is important. See, when the chief economic advisor read the economic survey report, he referred to an important data generated by IMF. This is not a government data. It's an IMF data. See, US and Europe are likely to grow at less than 2%. China has grown at 3 last year, and they are showing around 3 to 5. And IMF records India is the fastest growing economy at 6.5%.
Yeah.
So it's up to us to claim the pride and move forward and work, or feel still subservient.
Yeah.
The choice is definitely us. But one thing I assure you, we are now being heard. Our voice is heard. We are an important negotiator in anything that happens globally.
Yes.
So you can pick from there. All that I'm requesting youngsters is align your thoughts. Your individual aspirations and aims should have convergence in a national unity and spirit so that we ultimately add strength. Yeah. If that happens, then the growth will not be arithmetical. It will be geometrical. It is possible with the population and the talent we have.
Perfect.
That's the faith all of us have.
So before closing the webinar, could we just show the competition law database? My colleague Manjari has...
I'm surprised you have reported 1,300 cases here.
Yeah. Yes, sir.
I mean, even I didn't know this.
Yeah. Manjari, could you just pull up the screen, the competition law database screen? Yeah. So this is the competition law database, and could we select by, say, let's select by party name. Can we select by Google? And let's see whether CCI judgment hopefully gets thrown up here.
Yes.
Yeah,
Yeah.
great. So these are the judgments where Google is there. Can we just go upstairs and can we look at some more? We can select by industry. Could you just scroll up the industries, Manjari?
Yes.
Yeah. Could we look at digital payments? I think I saw digital payments or digital payments.
Yes.
Yeah. Bharti Airtel. Yeah. Okay. Okay. WhatsApp. Next. Visa. Yeah. Cremo. Fine. Next. Okay.
Bill desk.
Yeah. We can go upstairs again. Amazon. Yeah. Yeah. Absolutely. All these are the so these are the industry wise, and we have a lot of industries. So
Over 75 industries we have.
that's
Oh,
wonderful.
oh, oh.
That's wonderful. We could, yeah, great. We could go to the next one. We could, you can even search by date of judgment. You can search by the Competition Act section reference and nature of issue. That's the what we say, what we call, that's a crown jewel. So you could look at, can we go to the issues, Manjari?
Yes, sir.
So
So
any
these are
issue you
the,
want to select? Abuse of dominance, go to, let's select the issue.
yeah. So these are the issues under abuse of dominance.
Denial of market access, you put.
So we have some 113 judgments on this
Oh,
issue.
oh, oh.
Yeah, could we just keep coming? And can we refine this further, Manjari?
Yes, sir. Like,
How
by
come?
what?
By say whose favor it is?
So we can refine it by the judicial hierarchy and like the section numbers.
Okay, so let's refine it by the judicial hierarchy. Can we just look at High Court?
Any specific high court or like?
Yeah, we can go general.
Put Delhi High Court.
Delhi High Court. Sir is saying Delhi High Court.
Oh,
We have two in this.
oh, make my trip. Yeah. I argued it in Delhi High Court. Yeah. I remember.
Yeah. So we have this competition law database, and we have 1,300 cases now, sir. And you can search by nature of issues, by industry, by party name, the section reference. Yeah, why don't you search by council name? Why don't you search sir's name, and we'll see how many cases throw off now. Please don't misspell. You can just, yeah. Can you? Yeah, just select everything. Just give us a minute, sir, so that we can showcase this. We have, yeah, this is the Madras High Court case on the electricity. Yeah, this was also a case that you had argued, sir.
Yeah. In these 3 years, should have argued at least 50, 20 cases.
Absolutely. So you will get it. Maybe we could just type Venkataraman, and that should be good enough. Just type that. No, I think. Yeah, maybe this part needs to be fine-tuned a little bit, sir.
No problem.
Trying to do it, but it's one of its kind competition law database, and with the law assuming such importance, I hope that those who are discerning followers and discerning implementers of the competition law, advocates in competition law, practitioners can subscribe to this competition law database. You can contact us at sales@taxsutra.com and subscribe to this competition law database or lawstreetindia.com. Thank you so much, everyone, for joining in. So this was a masterclass in competition law. The first 10 minutes where you explained how competition law works and how exactly the CCI operates in terms of proceeding to decide whether in a particular case and particular set of facts it amounts to dominance and abuse of dominance. I think that essentially is the crux of any matter, and so what a big win it is for the Competition Commission, a big win for I don't know whether it's for the consumers or not. So yeah, possibly for the consumers, but I think it's a huge moment in competition law for the country, for India, and I think this definitely elevates the importance of competition law and adhering to competitive practices and not being or not laying a trap for anti-competitive practice. I think it elevates the very importance of this law to a different level. Sir, once again, congratulations for arguing this seminal case. Thanks so much for sparing your time for us, sir. And thanks everyone for writing in those questions and making this webinar interactive. Profuse thanks, sir. Profuse thanks.
Pranams. Thanks all of you. Thanks, Arun. Thanks all of you. Namaste.
Yeah, and for our viewers, just a quick note. Venkat sir will be speaking at the Taxsutra Conclave, which is going to be held at the Oberoi, Gurgaon, between May 3rd and 5th. He'll be delivering a special address that is going to be, of course, on tax, not on competition law. So we look forward to hearing you, sir, on your favorite subject.
Thank you. Pranams. Namaste.
So
Namaste.
thanks everyone. Thanks again. And we will be back with another webinar. Have a relaxed, long weekend. Good Friday. It is a holiday. Long weekend. Monday, we are back with another webinar on foreign trade policy at 5 p.m. sharp. See you Monday, April 10th, 5 p.m. Until then, goodbye. Have a nice weekend. Thank you.
Arun, can I exit?
Sure, sir. Thanks.
Pranams. Thank you so much.
Thank you, sir.